as an initial matter, this court should hold that the Court of Criminal Appeals erred in holding that it did not have subject matter jurisdiction to consider the merits of Mr. Gevedon's appeal. In its holding, the Court of Criminal Appeals determined that it did not have subject matter jurisdiction because the trial court did not establish a discretionary payment schedule that Mr. Gevedon would be obligated to pay in terms of the $30,000 and change in restitution from his jail cell. Although the trial court in this case, I suppose, could have ordered Mr. Gevedon to pay X number of dollars per month, I think it equates to just shy of $850 if we were to divide $30,490.76 by just shy of 36 months. The trial court could have done that, but it would have been an exercise in mathematical futility. All that was required by the trial court in terms of restitution was to set an amount, which it did, and then to set the time of payment schedule. And in this case, because there wasn't a payment plan, the default schedule would have been the 3 consecutive 11-month, 29-day terms pursuant to TCA 4035-304C.
Mr. White, let me interrupt you there. I want to talk a little bit more about this notion of a default. I mean, the statute to me seems pretty clear. The 304C seems pretty clear that the trial court shall specify a time of payment. Did the court specify a time of payment here?
But it's kind of, this appeal in particular is very unique because the trial court really acknowledged when it was making its order that Mr. Gevedon wasn't going to be able to pay this amount of money because of its statement that that the amount of restitution would basically become a civil judgment and that he wasn't going to be able to pay it, and that the trial court was more interested in punishment as opposed to payment. But when we look at the words of the statute are unambiguous if you look at the second sentence of 4035-304C, which states that in the absence of a discretionary payment schedule, the maximum amount of time that the trial court can implement in terms of requiring a defendant to pay restitution is that max term of probation supervision.
But so the court could, I mean, the court has discretion to set a shorter time period.
It does.
So absent some ruling by the court as to what the payment is, I mean, why is it permissible to say that the maximum is the default when the court has discretion to enter a shorter period and the statute requires the court to specify the time for repayment?
Well, I think the key word there is the discretion. If the defendant is very wealthy and has, let's say the defendant is a millionaire, that defendant would easily have the ability to pay $30,000 and some change in restitution within really a couple of, walk down to the bank, get a certified check, and walk back. But in this instance, if it's very obvious that an indigent defendant who is going to be serving the entirety of his sentence isn't going to be able to pay, either go down to the bank or be able to work and make payments, then in the absence of a specific time, the time, according to subsection C, is the expiration of the term of probation supervision.
But that could, I mean, that kind of hypothetical that you gave just shows that what's reasonable as the default may vary depending on the factual circumstances of the case. And so, I mean, isn't that why it's up to the trial court to specify?
That's correct, and I would submit that that's the way that it should be. I think that the trial court is in the best position to determine on a case-by-case basis, based on the particular circumstances of a defendant, his or her ability to pay according to his or her assets and resources. So someone differently situated may very well have the ability to pay a lot faster. And I think that's why the legislature contemplated that the end of the term of probation supervision is the deadline, and therefore the time of payment. If you haven't paid by then you theoretically could have your probation revoked.
Mr. White, is it your opinion at this point that there's any difference between your position and the state's position?
As to this issue, there is no difference. I believe we're in
as to any issue in this case now.
I think there's one issue, and that relates to We're in agreement as to the three issues that the court crafted that were in the briefs. The only difference might be whether to remand to the trial court for further proceedings, or whether this court can hold that Mr. Gevedon will not be obligated to pay any restitution because of the fact that if he doesn't have any ability to pay restitution from inside of his jail cell, should it ever been ordered, and it was ordered, but because he's serving the entirety of his sentence and he doesn't have any ability to pay restitution from inside of his jail cell, once he finishes serving that sentence, he is no longer going to be under the jurisdiction of the trial court. The lingo that you use in speaking with defendants is flatten their sentence. Once he's flattened his sentence, he's no longer under the jurisdiction of the trial court. In this instance, he's serving misdemeanors. And this is not an instance where one can get parole. If this were a felony sentence, we might be able to remand and say, well, he may or may not make parole on maybe a 10-year sentence that he's serving. But in this instance, the only mechanism that he could have gotten for getting out of jail prior to serving the entirety of the sentence is basically a motion to be reinstated to probation.
And of course, as long as he's under the jurisdiction of the trial court, we know that by statute, they can come back every so often. I think there's a limit on it. I think it's every 3 months, and ask for, him to be released back on probation, sentence reduction, whatever. That could still happen in this case, right?
It could, assuming that he hasn't already flattened the sentence. That's not in the record. And
but also you have a situation where, even assume someone's in jail. Use your millionaire example. If the guy's a millionaire and he's in jail, he's still got an ability to pay. And here, the trial court just didn't consider anything, right? As far as an ability to pay.
I agree with that. And there was zero consideration of it.
So wouldn't that countenance us to remand the case to the trial court for another hearing?
It could, and I guess we would want to have some leeway as far as direction to the trial court in terms of
Like follow the statute?
It's a different trial court now. The trial court that was in place is retired. But
be careful.
But follow the statute, and if in fact Mr. Gevedon has already served the entirety of the sentence, in my view, it becomes a civil issue if the victim or victims want to pursue Mr. Gevedon for that. As long as the statute of limitations hasn't expired, then they're free to do that. But
we know this defendant was employed. We also know his employer agreed to take him back, right? So there's such a thing as work release, things of that nature?
That's true, and he may have received work release. That's not in the record either. But in this instance, as far as creating a final appealable judgment, what the trial court did as far as a baseline minimum was sufficient. The judgment forms in combination with the probation revocation order setting a total restitution amount of $30,490.76 was collectively sufficient to create a final appealable judgment that was ripe for appellate review. And in holding otherwise, the Court of Criminal Appeals erred. This court should further hold that the trial court abused its discretion in setting that amount of restitution that Mr. Gevedon was required to pay from within his jail cell. As in the Cavan case, the standard of review is abuse of discretion with presumption of reasonableness. Mr. Gevedon would submit that the trial court did abuse its discretion. There's no presumption of reasonableness. The trial court didn't consider at all Mr. Gevedon's ability to pay from within his jail cell. It was just, well, this is the restitution amount. He's not going to pay it. That's why I'm going to summarily convert it into a civil judgment. And I'm more interested in punishment than in payment. And so that's clear abuse of discretion. And for reasons we've already talked about, this court should reverse that decision and either say that he's not going to owe any restitution at all, or probably the safer route is to remand to the trial court for a determination of did he do any work release? Was he reinstated to probation? Did he have any assets while he was in jail? And also a consideration of, has he finished serving this sentence? Because if he's finished serving the sentence, a remand at that point is asking the trial court to exercise jurisdiction no longer has. Because the trial court no longer has jurisdiction if he's finished serving the sentence. So if he's finished serving it, I think that's all we can do, and it becomes purely a civil issue at that point.
I mean, doesn't the possibility that it can be converted to a civil judgment prevent it from becoming moot? I mean, want to explore the mootness question a little bit more. I mean, I understand, I guess, that the trial court just may no longer have authority, but, I mean, how would this play out? I guess if there is still the possibility of this being converted to a civil, I mean, you seem to argue that it has already effectively been converted to a civil judgment. I disagree with that being what the trial court intended to do, but I mean, what does the possibility of this being converted to a civil judgment in the future, how does that affect the mootness question?
Well, I think in order to answer that question, you have to put yourself in the position of the trial court when the trial court was making its decision in this case. The trial court was faced with two issues at the time of this hearing. One, did Mr. Gevedon violate his probation? The court found that it did. And should that be a partial revocation? Should it be a full revocation? The court found that it should be a full revocation. In making that decision, the trial court should have considered at that time Mr. Gevedon's financial resources and whether he had any ability to pay as he was sitting there, and whether he would have any ability to pay from inside of the jail, whether through work release or some sort of program in the jail that might pay him money. But the trial court, in ordering that Mr. Gevedon fully serve that sentence, the trial court was choosing punishment over payment of a restitution amount that high. And because the trial court chose punishment over a restitution amount that high, I don't think that ordering him, basically saying that that amount should remain in effect and then be subject to the victim or victims converting it into a restitution or into a judgment at this point is proper.
At what point will this defendant flatten his sentence based on the DUI that resulted in this damage for the restitution amount?
It's a little hard to calculate because at the local jail level, different jails do it differently. In the Murray County Jail where I'm from, if you're a trustee, you can get 2-for-1 credits and you can serve an 1129 sentence in 6 months. The Giles County Jail may follow more of a statutory scheme, and they may follow the 75% rule, such that you would serve 75% of each one of those 1129s. And so when a defendant is getting out of jail is something I always avoid telling someone, because it creates a PCR issue that, well, you're going to flatten those 3 1129s in 18 months, when they may follow the 75% rule, and that may extend it another 9 months.
So do we look at all 3 DUIs? Were all 3 DUIs, was the restitution amount based on all 3 DUIs or just one?
I believe the restitution amount was based on Mr. Gevedon driving through a cemetery. And so as far as I understand from the record, that was isolated to one incident.
Okay, that's the way I read it as well.
He must have had quite a trip to that cemetery for $30,000 worth.
Exactly.
Unfortunately so. But again, to answer Your Honor's question, I think it was a choice. Do we want him to pay it? Whatever that amount should have been, I would submit it shouldn't have been $30,000 regardless. Or do we want him to pay with a pound of flesh? And that's what the latter is what the trial court chose. The final issue is, did the trial court abuse its discretion in summarily converting the restitution amount into a civil judgment?
Is that really what happened? I mean, I think that's a bit of a stretch to say that was kind of what the trial court was intending to do, was to convert it and automatically convert it. I mean, I read that to be more of a prediction that that's what's going to happen.
Or letting the parties know that that statute's available.
Was there a written order to that effect saying it was converted?
There was not. I believe the words, to quote the trial court, was, this will become a civil judgment, most likely and totally.
Well, she could have just been predicting what she expected to happen.
He said, I think so too.
That is true. But at the same, all I can go by is what the trial court was stating, which is this will become a civil judgment, most likely and totally. And if that was the trial court's intent, that was error, because the the defendant's sentence has to expire. And then once the defendant's sentence has expired, the victim then has a year from that date to file a certified copy of the judgments with a civil court, give the defendant the opportunity to file an answer, and then ascertain what amount of money, if any, remains to be paid. Obviously, that process wasn't followed, and if anything, I would like the court to clarify that if it was the trial court's intent to summarily convert it into a civil judgment, that was improper, and that the defendant, or excuse me, the victims should only have the opportunity to convert restitution to the extent there even is a restitution amount that should be ordered within 1 year of the date that he's finished serving his effective sentence.
Well, based on that court's oral statement, you really had no choice but to assume it was a civil judgment and appeal that.
That's correct,
really
Your Honor.
Makes sense.
And so just out of being cautious, that's what we did. If there are no further questions, I would ask the court to reverse the decision of the Court of Criminal Appeals, reverse the trial court's imposition of $30,490.76 in restitution, find that Mr. Gevedon has no ability to pay restitution while serving the entirety of his sentence as an indigent defendant in a jail cell, hold that the trial court abused its discretion in stating at least that it was going to summarily convert it into a civil judgment, and ultimately hold that Mr. Gevedon will not be obligated to pay any restitution as part of the criminal case. If the victims want to pursue him civilly, they have that avenue available to them, but the trial court chose punishment in this case. Thank you.
Mr. Brandon, let me ask you essentially the same question I asked Mr. White, and that is with regard to the differences in your position with regard to this case as of today, setting aside for a moment his argument that we as a matter of our own accord should state that there can't be any restitution. Is there any difference in your positions here today?
I don't think so, Your Honor. As to the law on the finality of the judgments and the trial court's error in setting an unreasonable amount of restitution and converting the judgment into a civil judgment, I don't think there's any space between the defendant and the state, which may be unusual, but...
I didn't see, I'm sorry to interrupt, I didn't see in your brief, I guess, an express agreement with the defendant's position that in the absence of something from the trial court specifying the time of repayment or time of payment, that there's kind of a default rule that applies. I think in footnote 2, you acknowledge that the trial court did not actually specify the time for payment. But if that's true, then how do we have a final judgment here in the absence of some kind of default rule?
I think the answer, Your Honor, is that we have an erroneous judgment in this case, and the other errors in the judgment complicate the time for payment issue. But in the state's view, what the trial court did was immediately convert the restitution into a civil judgment, effectively making the time for payment immediately.
But how can you take that position given the language most likely?
Your Honor, beyond just that sentence where the trial court indicated that it would be converted to a civil judgment, that viewed in light of the rest of the transcript and the trial court essentially choosing to forego the normal procedures of restitution and setting restitution that would be paid during the course of probation and setting an order that was unrelated to the defendant's ability to pay and then stating that it would be converted into a civil judgment, we think taken together indicates the trial court's intent to convert it to a civil judgment.
So are you saying that the reason this is a final judgment that is ripe for appellate review is because it at least is tantamount to a civil judgment?
No, Your Honor, I think the reason that this judgment is ripe for appellate review is that the trial court dealt with all the business before it, to put it in a short way.
Other than specifying a time for payment?
Well, I guess there's two ways to look at it, Your Honor. From the state's position, we read it as specifying an immediate time for payment that lapsed and converted to a civil judgment. If Your Honors disagreed with that characterization, the failure to, if this court reads the trial court's order as indicating that it would set a that it would be convertible to a civil judgment at a later time and failed to set an explicit time for payment, I think the state's position is that that would just be reversible error and not an issue that created a lack of finality in the trial court's judgment.
Why is that? I mean, when both of the requirements that the trial court, I guess, specify the amount of payment and the time for repayment, they're part of the same statutory provision. I take it that you would treat the failure to specify the amount of payment or the amount of restitution would preclude appellate review, but the failure to specify a time for payment would not?
Not necessarily, Your Honor. I don't think the distinction is between the amount and the time. I think the question for this court is whether the trial court left anything to be done at a later time. There are numerous statutory directives from the legislature about what a trial court is required to do during sentencing. Trial courts don't always follow those directives, and every time that they fail to follow a statutory directive, including one that's mandatory, doesn't necessarily mean that their judgment is not final. It's only not final when it leaves something out for the trial court to do.
So for example, if a trial court says, I need to set the amount, we need to determine the amount of restitution, doesn't get around to that for a while, the defendant appeals, that would not be right for appellate review. The appellate court would lack jurisdiction because something was left to do. The trial court was clearly contemplating that it needed to set an amount of restitution and just hadn't done it yet. But let's say the trial court says, I'm just going to order restitution, have no intent to set the amount. I'm just, going to let somebody else figure that out, but I'm not going to do it. This is final. I'm done. Does the appellate court have jurisdiction then?
I think so.
And that might be an absurd hypothetical that's not likely to happen, but is that basically your position?
Yes, Your Honor. I think that illustrates the distinction between a final yet erroneous order or a non-final order that contemplates some action in the future.
Okay.
Because here the trial court contemplated that it was done with its work, however erroneous that work was, the order was final, and the Court of Criminal Appeals should have addressed it on the merits and reversed it and sent it back. And to answer Your Honor's question specifically about the appropriate relief in this case, this court should remand the case to the trial court. There are certainly some sticky questions about the status of defendant's current status of his incarceration, whether there's time left in a sentence, whether, as Mr. White put it, he's flattened that sentence yet, and then if he's not, whether ordering restitution in this case is reasonable and what that amount should be, and the trial court's in the best position to make those decisions and come to a correct judgment and a final judgment on those issues. And so state believes that the appropriate relief in this case is to remand the case back to the trial court for entry of new judgments addressing those issues.
And what issues would the trial court resolve at that new hearing? Would the court take another look at the restitution amount?
I think the first question for the trial court to resolve would be whether it can order restitution, given defendant has been serving a sentence as far as I know, and whether the sentence has expired. And secondary to that question, whether the trial court was going to exercise its discretion to order restitution, even if it could. At that point, the trial court may decide that it's time for this case to be put to bed and that this should become a civil matter. If it did exercise its discretion to impose restitution, then it, of course, would need to follow the statutory directives and set a reasonable amount of restitution. And so, because there's quite a few issues outstanding and steps for the court to go through, state thinks that it's best to send that back to the trial court to allow it to make those decisions and sort out some of the complexities of this case.
I'm trying to figure out the procedural posture. If we were to decide this is not a final judgment because no time for payment was set, and the defendant has served a sentence, what's our procedure? What would we do?
Well, if the judgment was not final, I guess the first step would be to remand it to the trial court. I think Your Honor's hypothetical illustrates some of the problems with holding that a simple lack of time for payment is a jurisdictional non-finality error as opposed to just an error, that these judgments could sit out there for years and not be final if the trial court just doesn't set a time for payment but doesn't contemplate any further action. But if this court went that route, I I think the appropriate remedy would again still be to remand to the trial court for entry of a final judgment. And
So you still think that we should assume by default, if no time for payment is set, that the trial court intended it simply to be set at the end of the period?
not necessarily, Your Honor. I think if there is no indication of a time being set, I think this court could hold that that's just error and that there needs to be a time set. The statute does limit the time for payment to no later than the end of the statutory maximum term of probation, and in a case that's less clear, where there's some indication that the trial court was setting a time for payment at the end, maybe reading the statute in conjunction with the trial court's order would be appropriate to infer that it was setting it at the end of the time of probation. But here, at least in this case, it's clear that the trial court is not intending to set it at the end of probation, that it either immediately or possibly at the end of the term contemplated a conversion to the civil judgment, and that it set an unreasonable amount of restitution. There's, again, multiple reasons that this case ought to go back to the trial court for correction of its judgments. Okay.
What would be wrong with this court adopting the default rule as proposed by the defendant here? I mean, what harm could come out of just assuming that if a payment term is not set, it's going to fall to the end of the probationary or the sentence period? It seems like that would make more orders, it would uphold more court orders. How would that hurt the state or the defendant?
I'm not sure functionally, too, how it's different. Because what you're saying is if no time for payment is set, we should not hold that deprives the appellate court of jurisdiction.
That's correct, Your Honor.
That's basically what you're holding. It's an erroneous order, but it's not a non-final order. Aren't we, in effect, setting the default that Justice Lee was referring to?
Well, I guess you're saying if the court does not set a payment term, it comes up to us or the CCA and it's just reversed and sent back. The court has jurisdiction to hear it, but it would just be a reversal and sent back for the trial court to make that determination.
That's correct, Your Honor.
Which maybe in most cases would be pay it by the end of your supervision.
That's correct. And
I just wonder, why wouldn't we just skip to the end and allow that case to have that ending?
I think, Your Honor, in a number of cases that might be an appropriate inference from the trial court's order that it was set at the time of. I think the answer to your question is that it's going to have to be a case-by-case evaluation. In a case like this, where the trial court clearly did not intend that, did not contemplate that, then if there is any lack in setting a time of payment, I think the appropriate remedy is to hold that that's an error and reverse it. But in other cases, it might be appropriate to infer from the transcript of the restitution hearing of the trial court's order that the trial court intended to set the time as the end of the probationary period if it didn't set an earlier time. Unless Your Honors have any further questions, again, the parties agree on the issues in this case, that the Court of Criminal Appeals erred by holding that the trial court's judgments were not final, and that the trial court erred by setting an unreasonable amount of restitution and converting that to a civil judgment. So this case should be remanded to the trial court for correction of those errors.
Thank you, Mr. Brandon. Mr. White?
Your Honors, unless there's any further questions, I would ask this court to grant Mr. Gevedon the relief that I previously requested.
All right.
Thank you.
Thank you both. I believe that concludes our docket this morning, so we will be adjourned.
All rise. This honorable court is now adjourned.